Hello, everybody. I'm Gabriel Rosenfeld, the president here at the Center for Jewish History. I'm thrilled that everyone can be here in person to this evening's lecture, which will bring to a close the second and I guess final phase of our exhibition, How Jews Became Citizens. Some of you may have been in the audience in recent weeks when we were privileged to hear talks by prominent scholars on the subject of Jewish emancipation in Europe, in the Middle East, in Russia as well. Tonight, we're going to be moving closer to home and turning our attention to the case of the fair United States. To get us started, I'm going to turn things over to our Director of Programming, Dr. Miriam Mora, to formally introduce this evening's speaker, Lila Corwin Berman of Temple University. So please welcome Miriam.
Hello, everybody. My name is Miriam Mora. I'm Director of Academic and Public Programming here at the Center for Jewish History. And I'm very excited to welcome you today for this talk with Dr. Lila Corwin Berman. This is the third and final lecture in our Sid Lapidus lecture series, created to expand upon the collection and exhibit right down the hall, How Jews Became Citizens, which tells the complex and ongoing story of the Jewish people's path to emancipation in Europe across centuries. This program has been made possible by the generous support of Sid and Ruth Lapidus, as well as the New York State Council on the Arts and the New York City Department of Cultural Affairs. In tonight's talk, It's Hard to Find a Loophole for Admitting the Hebrews, a 20th Century History of Jewish Emancipation in the United States, Professor Berman will dispel the assumption that Jews coming to America were simply emancipated upon arrival, demonstrating the struggles for emancipation throughout the 20th century, which often aligned American Jews with other groups seeking the full rights of citizenship. I'm going to ask you to hold your questions. There will be time for a Q&A at the end, and I will come around to you with a microphone to ask those questions so that we can capture them in our recording of the event as well. Dr. Berman holds the Murray Friedman Chair of American Jewish History at Temple University, where she directs the Feinstein Center for American Jewish History. Her most recent book, The American Jewish Philanthropic Complex, The History of a Multibillion-Dollar Institution, has been awarded the 2021 Ellis W. Hawley Book Prize from the Organization of American Historians and the Saul Viener Book Prize from the American Jewish Historical Society. She is currently working on a new book called America's Jewish Question about the inclusions and exclusions of American liberalism. I am delighted to have her with us this evening. Please join me in welcoming Dr. Lila Corwin Berman.
Thank you so much. I'm just delighted to be here with all of you. And I really want to thank, first of all, Sid Lapidus, who, although not here, has really just given so generously of his time and of his passion and of his knowledge to the Center for Jewish History. And I feel very grateful to him. And I'm thankful also to Gabrielle and Miriam and Judy for all of the work that has gone into putting together this series. So I spent some time in the exhibit, and I hope you've had the chance to spend some time in the exhibit. And one of the things that I learned, probably the main thing that I learned from it, is that the process of emancipation produced volumes, right? It's an exhibit that focuses on all of the different books and the tractates and the treatises that were written about emancipation. And that in the attempts to imagine emancipation for Jews and for other groups, thinkers were really imagining a new world. They were imagining things about nationhood, about subjecthood, what does it mean to be the subject of a nation, about power and about justice. And obviously, this was not a clear project, right? Had it been really clear, I don't think so much ink would have been spilled on what did it mean to become a full citizen, to have full political and legal rights. So all of this, as I was moving through the exhibit and reflecting also on my research, has gotten me thinking about a subject about which far fewer words have been spilled, which is Jewish emancipation in the United States. And the received story of this is that there's actually no story to be told. So what we learn when the question is asked about Jewish citizenship in the United States or emancipation, the process of gaining full political and civic rights, is that it's a simple story and it's a very triumphant story. that Jews never had to receive emancipation as an award in the United States, and that Jews could secure legal and political emancipation simply by entering. This has been the controlling assumption, I would say the foundational assumption of American Jewish history. The certainty that Jews simply kind of arrived into this uncomplicated state of emancipation is so foundational to the field of American Jewish history, and that they gained full and political legal rights as individual citizens without undergoing a kind of ordeal of emancipation, right? The ordeal that is really exhibited in the room down the hall. And my question for us tonight is really simple. The question is, really? That's it. That's my question. And what would it look like to seriously study the process by which American Jews both gained and inhabited citizenship in the United States? And my theory of the case is that if we approach this topic with curiosity as opposed to certainty, which is how it has been approached, we're going to learn a fair amount, not just about the history of American Jews, but also about the legal and political architecture of American citizenship. So to help me answer my question, really, I am relying on scholars in part. And one of the scholars, David Sorkin, is somebody who actually helped put together the exhibit. And he spoke on the opening panel, I think, right? And he has written this really incredible broad volume called Jewish Emancipation. And in it, he argues that emancipation is complex and it's multidirectional, and that wherever it's occurred, there is always a kind of complexity to it. And he does offer some discussion of the United States, but he does conclude that really by the 1960s, there was really no longer any kind of emancipationist struggle for Jews in the United States. I'm also relying on historians and legal theorists like somebody named Linda Bosniak, who also have been writing about citizenship, basically disrupting, and I think some of the other lectures, if some of you have attended the full series, you've heard this, kind of disrupting the binary that you have either the citizen or the non-citizen, and instead thinking about the kind of thresholds and the complexities. What Bosniak said, writes, is that citizenship we shouldn't think of as an all or nothing affair. So I'm relying on that. And to be honest, I'm also relying on my observation of the last handful of years in American politics and how they've alit on the status of American Jews, and certainly hearing our former president talk about Jews and their loyalty to the United States versus their loyalty to Israel was something that was on my mind as I was thinking through some of these questions about citizenship. So for tonight, I'm going to present 3 different kinds of cases that I think help us think about how citizenship worked for American Jews in the United States. And all of these cases that I'm going to talk about are 20th or in fact 21st century cases. And just to kind of justify that choice, the reason is that although certainly there were debates about citizenship throughout the late 18th and the 19th century in the United States when it came to Jews, and there's lots of things we could say about that, in terms of being a sort of centralized federal system, the regime, the legal architecture of citizenship in the United States really took shape after the Civil War. And this is when you have the establishment of the Bureau of Immigration and Naturalization, lots of new statutory law about citizenship. And it's really a kind of response to the crisis of the Civil War. And what does it mean to kind of repair a nation? What kinds of centralized functions have to happen? This is when you see a really significant growth of the federal government as well. So the 3 kinds of cases that I'm going to look at all really reveal the critical ways that Jews became embedded in very core questions of American citizenship about legal belonging and exclusion. So I'll talk about each of these kinds of cases in a minute: Jewish comparison cases, cases that have to do with formal citizenship, whether one has it or not, and then what I and some others call effective citizenship, right? What is the substance from within citizenship, even once you have citizenship, how are there conditionalities, thresholds, some ways in which your effective rights are greater or lesser than other people's? But even though I'm talking about each of these separately, I want you to be thinking so I learned this from a teacher I had who would always say to a seminar, kind of right at the beginning, if you get a little bored with what I'm saying, here's like a question I want you to be thinking about. So I want you to be thinking about some of the connections among these three kinds of cases, and thinking about the ways in which the themes from these different cases that I've kind of classified in this way cut across. Okay, so we're going to start with what I call Jewish comparison cases. These are cases that on the surface don't appear to include Jewish subjects. So if you went to some kind of database and you're like typing into your search engine cases about Jews and citizenship, these cases would not come up. But the reason they're important, I think, is they invoke crucial comparisons to Jews in the legal logic that is being used to determine the ruling of the citizenship status of a petitioner in question. Okay, so all of these kinds of cases that fall under the rubric of Jewish comparison cases tended to arise at the end of the 19th century and the early 20th century, when jurists were really fixated on trying to interpret and understand the statute that really controlled how citizenship worked in the United States and apply it to this new context when you have so much more diversity, lots of new immigrants coming into the United States, and you have this desire to have a stronger, more federal, centralized kind of power of who gets to be an American and who doesn't get to be an American. And these cases all hinged on an important act. It was one of the first acts that the American Congress passed in 1790 that defined who could be an American, right? Any alien being a free white person. And when they said person, what gender? Yeah, okay. Male, you nailed it. Yes. Okay. So free white person, right? So this had been the only real kind of statutory standard of citizenship that the federal government pronounced. And as I said, otherwise, it was really something that varied state by state. Different states had different ways of kind of qualifying citizenship. Sometimes it was very local, right? A particular village or county would have its own kinds of determinations about how citizenship worked. But after the Civil War, an era that Eric Foner, who's an important Columbia historian, has called the kind of second founding, Congress kind of spins around and casts new attention on immigration and naturalization that had really kind of not given much attention for almost a century. And this period of trying to figure out how to assimilate a whole group of people that had been in servitude into citizenship causes all sorts of new, not only statutory law, but actually amendments, right? So the 14th Amendment that defines how naturalization will work as a kind of birthright, right? So birthright citizenship, if you're born in the United States, you're a citizen, right? That's clearly articulated. And then an amendment that's passed shortly after that also says that this amendment to the Constitution is applicable to those of African nativity and African descent. So you still have the 1790 law, and now you have a kind of addition to it that free white people and people who are of African nativity and African descent can be citizens. Closely on the heels of all of this is one, the creation of the Bureau of Immigration and Naturalization. So with this law, I mean, there's a funny dynamic, right? Because it seems like suddenly there's more capacity, right? A kind of opening. And yet immediately you see a kind of closing. So the Bureau of Immigration and Naturalization, which is meant to be the administrative body to regulate who is let in under the law, starts to regulate and try to figure out how to apply these laws. And the Chinese Exclusion Act comes very shortly after in 1882, right? So pay attention to that dynamic of sort of opening and narrowing. And this initiates a kind of era of what one legal historian calls racial prerequisite cases. Cases where somebody who wants to be a citizen must prove that they fit those categorical thresholds. Free, white. At this point, women are given more access to citizenship, but not entirely, certainly not the effective rights of citizenship, right? They're not, for example, allowed to vote, right? So free white persons or people of African descent or nativity. So the case that I want to talk about that helps us understand how this Jewish comparison starts to be important is one of these quote unquote racial prerequisite kinds of cases. It starts in 1909. 4 men appear before a Massachusetts federal judge, Francis Cabot Lowell, right? So some of you might know the Lowell, if you went to Harvard, you lived in the Lowell house maybe, right? So this is the Boston sort of elite Lowell family. And these are not the petitioners, right? But it's important, I think, as I give you some of the details, to think about what Lowell thought he was seeing. These were 4 men who had come from the Ottoman Empire, and they were described in filings that they had to make with the Bureau of Immigration and Naturalization as being Armenians by race. And they were, based on those grounds, denied citizenship, right? The Bureau of Immigration and Naturalization said, these are not free white people. They're certainly not of African nativity or descent. They may not be citizens. So they appeal. And when they enter Judge Lowell's courtroom, he observes, and he wrote this actually in part of his kind of filings about the case, that they were white persons in appearance, right? So that's what he writes. But he's also aware of the gravity of these cases, right? These are self-definitional to what America is and who gets to be an American, right? Who gets to be part of this sovereign nation. And so he searches for a more empirical and replicable logic, right? So if the standard is only like, okay, the judge will look and do sort of a visual survey of who appears to be white, Lowell is aware that that would have some shortcomings, right? And so he enters into the logic of comparison. If there's some lawyers among you, you might know that this is something that I think is one of the tools that lawyers use to puzzle things out. So he thinks, well, to which other groups might we compare these 4 men who are petitioning for citizenship? And he thinks about Russians, and he talks a little bit in his opinion about quote unquote Anglo-Saxons. And finally, he lands on Hebrews. And what he says is that there's a funny contradiction. And you read these opinions, and it's sort of funny because you could sort of imagine, like, at some point, some of these judges are just writing what they're thinking, right? And, they're like, oh, I hadn't thought about it this way. I always wonder, like, with someone like, you might want to edit some, it like some of the parts end up being sort of these flights of just, they're puzzling things out. And to the historian, this is incredibly useful because you get to see how this person is thinking, right? This agent of the American state, this person invested with state power. And he discovers a contradiction, he believes. He says, okay, what we know is that the law actually distinguishes among 2 admissible groups of people, who he describes as whites and Negroes, those are the words he uses, and an inadmissible group, which he describes as Asiatics. Okay, that's the rubric he says he knows. So where, he asks, does the Hebrew fit? And how might puzzling this out be helpful in this case? And he says, okay, well, let's understand what is the race of the Hebrew. Because he says he's certain he knows they're a true race, and he's certain that they are Asiatic in origin, like Hindus, he says, and that he knows Hindus had been disqualified on the grounds of being Asiatic. And that's how he knows that that third category of humanity that he designates as Asiatics are not applicable for American citizenship. So he says, well, most certainly then, and these are his words, a like argument applies to those, to Jews, who have suffered most cruelly among all men on earth from European hatred and contempt. And for another time, if we were sitting with sources and reading closely, I would ask us to really think about, why is he pointing out the fact that Jews have been so hated in Europe? Is this a way of kind of eliciting a certain compassion for Jews? Or is it a way of saying, they haven't really been accepted into European ideas of belonging. Could be both, right? And so he says, and yet here's a puzzle. Despite all of this, Hebrews have gained American citizenship. And he writes, if the Aboriginal peoples of Asia are excluded from naturalization, it is hard to find a loophole for admitting the Hebrew. He's astonished, basically, and he concludes that the only reason he can imagine that Jewish people have managed to gain citizenship in the United States is it's just an extraordinary exception. And it contradicts the basic principles of American citizenship law. Now, he kind of reins himself in eventually, right? So he's going on and like, oh my goodness, right? And he realizes it's not really his job as a judge to point out contradictions. Rather, he is supposed to render some kind of judgment. So he essentially turns what he calls this extraordinary exception into the rule. And he says that therefore, this must mean that these 4 Armenians could be naturalized and that somehow whites must have the capacity to absorb them, right? Because of this extraordinary exception that he has found. He knows his reasoning is pretty flimsy, and it's premised on a comparison that actually revealed a sort of damning contradiction. And so he actually ends his opinion by calling on Congress to legislate and give more specificity to what kinds of persons are really meant to be admitted to citizenship. And what's interesting is when the New York Times reports on this case, it highlights, I don't know how well you can read it, but it highlights that loophole statement, right? It ends up being a kind of concluding paragraph of the article. And you better believe that Jewish Americans, especially jurists among them, and especially some of the leaders, notice that. And it's concerning to them, right? Because what does this mean for their status if in this kind of Jewish comparison, yes, the ruling actually kind of cut in their favor, but barely, right? It pointed out this kind of problem. So to get us to think about that, there's this other case. And one thing that's so fascinating to me is, although some historians have talked about these cases, Jewish historians have not at all. And the historians who have talked about them have made no mention of what I'm calling this Jewish comparison, right? So I think there's actually like a kind of much deeper analytical way of thinking about these cases and thinking about American citizenship and Jewish citizenship than we have seen so far. So shortly after Lowell renders his verdict, 2 Jewish jurists, right, whose names might be familiar to some of you, Louis Marshall and Max Kohler, file a brief, right? They're both lawyers, and they file a brief to intervene in a citizenship case that had started also in the spring of 1909. And this involved a man who's described as Parsi. His last name is Balsara, and he's born in 1872 in Bombay, and he describes himself as having Persian roots. And he is initially told that he cannot be a citizen, so very similar kind of chain of events. But for him, he then appeals to a New York federal circuit judge who decides to admit him to citizenship because, quote, he appears to be a gentleman of high character and exceptional intelligence. Now, that's not really the standard that is meant to be used, but that judge sort of realizes he's playing a bit fast and loose, and he says, anyway, my decision is not particularly significant because I know the government is going to appeal. Okay, so maybe that's a strategy a judge could use. This case catches the eyes of Marshall and Kohler. And when I discovered that they had filed this brief in this case, I was kind of curious, right? And it took the fact of finding in their brief the loophole statement from Lowell for me to understand why they were on high alert to pay attention to these kinds of cases. And they were clearly worried that in different hands, the comparison might rule the Jewish exception not as precedent, but as a mistake. So they joined the case on its appeal from the government, because indeed the government does appeal to the Second Circuit, and they join it representing the quote unquote Syrian interveners, right? So these are interveners, these are people who say we have a very particular interest in this case, and therefore we deserve to be sort of represented in the deliberations of it. they say, the Syrian interveners say, our citizenship is actually hanging in the balance of this judgment. So Kohler and Marshall file a brief, and they argue, they work on litigating the case, and they say in their brief that a denial of Balthazar's citizenship could, quote, render invalid thousands of decrees of naturalization heretofore made. And it becomes clear that they're not only thinking about their client, the Syrians, and they're certainly not only thinking about Balthazar, they're thinking about the Jewish comparison. The crux of their argument in the brief that they file returns to Lowell's Jewish comparison. And they quote it and they try to solve it. They say, okay, this judge decided there was a contradiction, and in fact, he's wrong. And the way that they do that is by introducing a kind of subcategory in that Asiatic category, right? Operating totally in this frame of kind of a racialized scientific knowledge. And they say that you have Asiatics who are white, and they are part of what they call the Caucasian race. And they argue that Jews are Asiatic whites. And they say the way we know this, and this is such a curious, interesting logical process, is that Congress let Jews become citizens. And they list all of these different Jews from the late 18th century and into the 19th century who surely Congress people knew were Jewish and had certain kinds of citizenship privileges. So they knew that they had the law, and they knew that there were Jews who were citizens. Ergo, they must have believed that Jews were white, and the kinds of whites they were these Asiatic whites. And to drive home the point, they write, what could be more unjust and absurd than to say that Jews, Turks, Greeks, Armenians, Russians, etc., born in Europe are entitled to being white people? Well, if you were born in Asia, you're not, right? That it can't just be a kind of geographically defined category, but that in fact, there is this sort of idea of a different category of whiteness that Jews are a prime example of. Right? So they're extending the comparison, and they're saying this, in fact, should be the basis for how we think about the law. But even as they categorize Jewish citizenship as settled policy in their brief, they know they're litigating it. They call it a preposterous proposition to render a verdict that threatened the citizenship of worthy and law-abiding citizens like Jews or Syrians, right? And I think that the kind of hyperbole of their rhetoric is showing this kind of concern about what will happen if this kind of legal logic is extended. Now, as they're doing this, they are absolutely aware of the political headwinds, right? That nativism is on the rise, that there's rising fervor to restrict immigration. In fact, both Marshall and Kohler testified to the Dillingham Commission that Congress had to sort of try to figure out what to do with the quote unquote immigration problem. And they're also betraying their own nativist presumptions, right? So they rely on scientific racism to distinguish between white and non-white Asiatics. And they worry, they write, that should Hindu coolies and Hottentots and Bushmen invade the country, there is certainty that Congress will act to make sure that that is stopped, right? That there's no slippery slope argument about letting in one group of Asiatics and then worrying about others. So they're absolutely kind of operating within this framework, but at the same time trying to do something else with the Jewish comparison to say, no, this should be a kind of vector of inclusion, not for everybody, right? But according to the lines of this other kind of logic. And they succeed, right? Because on appeal, Balthazar is admitted to citizenship as a Caucasian. And the Jewish comparison from Lowell to Marshall and Kohler, and finally to the verdict in Balthazar, is embedded in the verdict. When the judge says, if a Hebrew, a native of Jerusalem, had applied for naturalization in 1790, we cannot believe he would have been excluded on the ground that he was not a white person. And you can imagine Marshall and Kohler are saying, very good. Thank you for reading our brief and putting it in your opinion, because that's exactly what happened in this case. And the Jewish press was watching and rejoiced. different outlets that report on this verdict, right, which again seems quite removed from anything that would have been kind of in the crux of what Jews are thinking about, but they're reporting on this. They call the brief a permanent contribution to legal literature. They say the judgment was a clear rebuke to Lowell, who just didn't understand the special statutes, grants, and history of Jews in American colonies. And they acknowledge direct implication of the verdict for Jews, though Jews had only been named indirectly, right? And the fact that these cases have not really been kind of thought about and contemplated, I think, by historians in the future, means that this kind of instability, this sort of place where there's softness and uncertainty and fear about Jewish citizenship has actually been erased, right? So that helps us kind of understand some of the logic of these Jewish comparison cases. Now, the second set of cases I want to talk about are formal citizenship cases. And what's interesting is that in these cases, Jews are being named directly. I'm going to talk about one case where a Jewish person is being named directly and is being stripped of his citizenship. But even these cases, right? So you might say, okay, but these are very, kind of indirect gestures toward Jews, and maybe it makes sense that historians haven't kind of thought of them as proving that there are these concerns about emancipation and citizenship for American Jews. I disagree, but okay, maybe. These next cases that I'm going to talk about, one, very directly named Jews, and yet also have not been really considered as a reason to kind of ask questions about the nature of Jewish citizenship in the United States. So these cases are direct interrogations of Jews' formal citizenship status. Some of these are fairly well known, right? And they tend to be about political dissidents, like Emma Goldman. And in most cases, when these are talked about by historians, the kind of Jewishness of the subject is mentioned or, not, it's like an adjective maybe that's used, but there's not much that's made of it because there's actually not a framework for understanding what to say about the Jewishness, right? And so part of my project is to kind of say there is something to be said about the Jewishness. But here I'm not going to talk about Emma Goldman's case. I'm going to turn to a much less well-known case from the 1940s that very directly considered the citizenship of a Jewish person and issued a challenge to it because said that his Jewishness was putting American national sovereignty in danger. And this is a case that has to do with a man named Louis Lapidus. And I don't think he's related to Sid. The spelling's different. Maybe Sid at some point will correct me and say there's some relationship. I'm not sure. So this man came to the United States in 1922 from Western Ukraine. He was naturalized as an American citizen in 1928. In 1934, he leaves for Palestine with his wife and his son. And in 1947, he tries to come back to the United States. He wants to visit his son who is in school in the United States. And he's detained at the border. And he is told that he has no ability to come into the United States as a citizen, that his passport is invalid. And his citizenship at that point is revoked. And the grounds upon which it's revoked are there's a 1940 Nationality Act, right? And it's part of this kind of litany of legislation of really formalizing and giving more administrative kind of oomph to citizenship in the United States. And one of the stipulations in this act, Section 404C, is that anybody who has become a national by naturalization, so if you weren't born in the United States, but you became naturalized, you could lose your citizenship if you reside continuously, if you live continuously for 5 years in another foreign state. If you were born in the United States, this was not the case. You could go live where you want. This was only for naturalized citizens. And so this, according to Congress and then interpretations of the statute, this is actually called voluntary expatriation. The presumption is that anybody who's a naturalized citizen who goes and does this must not want to be an American citizen. So that itself, there's a whole kind of interesting way to think about why it's being called voluntary, but okay. So Lapidus's case, he appeals and he says, I did not wish to renege my American citizenship. I'm being stripped of it, and I'm going to appeal this. So he appeals and he raises a basic constitutional question, which is, does this section violate the 14th Amendment? So why would, do we have lawyers here or people who like law? Why would this section violate the 14th Amendment? Correct. Yeah, so there's disparate treatment between citizens who were naturalized and citizens who were born in the United States. And the crux, one of the kind of key parts of the 14th Amendment is equal protection, right? Okay, so this is a constitutional question. There's some Fifth Amendment due process, but it ends up being really about exactly what you said. And what Lapidus's lawyers say is, this is unconstitutional, right? This is in violation of equal protection. What the government says is that there are times when disparate treatment is allowed, and one of the core times is if it is in the interest of national sovereignty, and in which case you can basically supersede the 14th Amendment, right? And if you remember cases after 9/11, right, this was part of kind of the discussion, right? The kind of urgent need to deal with something having to do with national sovereignty or kind of protecting the United States. So it enters into this kind of legal battle. And Lapidus loses at various stages. And he eventually is appealing at the kind of appellate level. And at that stage, two Jewish organizations get involved, the American Jewish Committee and the American Jewish Congress, right? And these were these liberal Jewish organizations that were founded in the early part of the 20th century. The ACLU gets involved as well, and I can tell you a little bit about that if you're interested. But I want to direct our attention to what the AJC and the American Jewish Congress end up arguing. They build a case to prove that the law under which Lapidus has been expatriated was meant to directly target Jews' access to formal citizenship. To actually, when I say formal citizenship, it means like that stark line, citizen or not, right? And the way they build their case is they dig into the legislative history of it. And they say, well, what motivated this particular law? And what they find is that Congress had actually been intending to have in the law, and this is going to get technical for a minute, but then that's it, I promise, right? They had intended to have something called a rebuttable presumption, which was the sort of sense that if you were found to have violated the law by living abroad, according to the kind of stipulations of the law, unless you went back to your country of origin, right? So say if you were from, France, and you go back to France and you live there for 5 years, that case you will be assumed to have wanting to expatriate. But if you go to a third-party country, the rebuttable presumption will say that more likely than not, you did not intend to expatriate. Okay, so that was how Congress was planning on writing this law. And had they done that, Lapidus would not have been expatriated. His citizenship would not have been stripped. So they asked themselves, well, what changed, right? So we're finding this legislative record. It's going to be written this way until like the 11th hour. And they find that at the very last minute, a State Department official kind of furiously races into Congress. I'm imagining, I don't know, maybe he walked slowly. And he testifies and he says, you must strike this rebuttable presumption, right? We in the State Department do not want to offer this kind of soft pedaling approach toward people, even if they're residing in a not their birth country. And what he says is that the principal case that we are worried about are these Zionists. They're principally Russian and German Jews who were naturalized in this country and later went to Palestine. Now, there is a long history of the State Department being very anxious about Jews kind of gaining American citizenship on the way to trying to build a national Jewish state, right? So that is already something that we know actually the State Department was quite worried about. And the American Jewish Committee in Congress, for those of you who, might kind of know a little bit about their history, they did not see eye to eye about Zionism, right? The American Jewish Committee was explicitly non-Zionist, right? They were not interested in Zionism. The Congress had a more kind of softened approach to it, and they had some very Zionist Jews who were members, and they had a more favorable kind of approach. But they both point to the kind of hand of American law bearing down on Jews when it questions whether somebody that is designated as a Jewish nationalist could be an American citizen. So they file two amicus briefs, and they both deploy the argument, first rehearsing this history. Both of them rehearse a kind of identical history. And what's interesting is the ACLU, also supportive of Lapidus, and certainly their staff lawyers had dug into this history. They don't talk about it, which I think is really interesting. But AJC and AJ Kong, they talk about this history, and they then say that it's absolutely odious, not just unconstitutional, to differentiate citizens because of ancestry, and that this law, if it's allowed to stand, would create, quote, a second-class citizenship not wholly dissimilar to that created by Hitler's Nuremberg laws. This is 1947. And that the law was an unwarranted invasion of rights that belonged to American citizens who were classified as, quote, these Zionists. So they're saying that this law was targeting particular kinds of Jewish citizens, right? That it was not actually meant to kind of be a broad enactment of a legal principle, but it was very targeted. Now, their briefs are absolutely not an honest assessment of American citizenship. And the judge who is reading them knows that. American law at the time, in fact, did allow quote unquote odious gradations of citizenship based on ancestry. What population had just been put in internment camps during World War II? Japanese, right? And so, in fact, one of the decisions that both of these briefs try to kind of make sense of is that, and they say, well, there was not the same kind of strong and urgent need to actually enact disparate treatment as there might have been in the case of Japanese internment. And also, American citizenship absolutely allowed for second-class citizenship. Brown v. Board was still 5 years in the future by the time this particular verdict comes out in 1949. So Lapidus loses his case, and he is refused citizenship. He appeals to the Supreme Court, and the Supreme Court says there is not really a federal question to be considered here. And what the judgment says and what stands is that there was reasonable relation to legitimate legislative ends. And that's that. And that is the same reasonable relation to legitimate legislative ends is the same language used in Japanese internment cases, and actually the same in cases that had allowed American women who were born in the United States to lose their citizenship if they married a non-American man. And although those laws had mainly been overturned by this point, they were still actually used as precedent to say disparate treatment could be okay in citizenship cases, right? So we see in these cases that the same kind of relational logic from those Jewish comparison cases, sort of scripting Jews into a larger logic of exclusion, is absolutely being enacted. And it's not about thinking just about individuals. It's about classes and categories of people, even though we tend to think of citizenship as a kind of individual affair. We also see how conditional, right, these kinds of thresholds upon which citizenship acts. And we see in this one how very contingent citizenship is on broader historical events. And I'll just very briefly say that in 1967, there's a very similar case to this one about a man who is Jewish, naturalized in the United States, goes to Palestine, and then it becomes Israel, loses his citizenship. And that case does go to the Supreme Court. And that case, Beis Ephraim, it's called, ends up actually being the case that is the architecture of dual citizenship in the United States. It ends up cutting the other way. And I could talk about that if you're interested. But let me just get to then the last set of cases that I want to talk about. And these cases have to do with what I call effective citizenship. And when we think of effective citizenship, there are kind of two pieces of it. One is to what extent, even if you have citizenship, you're a citizen, okay, to what extent, one, are you invested by law with full legal personhood, or what Jessica Marglin, who spoke at one of these earlier events, she talks about legal belonging, right? So to what extent, even from the interior of citizenship, do you have full legal belonging or personhood? And two, At what times can the extension of citizenship itself become an instrument of authority and subordination, right? So just because somebody is granted citizenship, and we certainly know this in the case of how citizenship played out for Black Americans in the United States, citizenship does not always necessarily open up into real emancipatory possibilities, right? Sometimes it can be an agent of subordination. So these two pieces of effective citizenship are important to thinking about this last case. And this one is a very recent case. And maybe some of you followed it or heard something about it. This is a case of a man named Joshua Bonadonna. And he was a man, he's still alive, born in Baton Rouge to a Jewish mother and a Catholic father. And he was raised, and these are the words he used to describe himself, culturally and religiously as a member of the Jewish community. He attended Louisiana College, which is in central Louisiana, and in 2021 actually became called Louisiana Christian University. So it's going to anticipate what happens. And he plays football there. And he ends up having a conversion experience and becoming Christian. He graduates in 2013. And in 2017, and I know this is small, so it's okay, you don't have to read it all. In 2017, he applies to go back to Louisiana College to be a coach, to be, I don't know the technical term, one of the, little people, not just assistant, but it was like a certain kind of, for some line of players of football. So, so he applies for that. And on his application, he testified to his Baptist faith, right? He's asked specifically questions like, what was your salvation experience? And tell us about your personal acceptance of Christ. This is a Christian college, right? It's not pulling its punches. And when he's interviewed, he's brought in for an interview with the head coach and with the president of the college. And he's asked about his parents' religion. And he says, the Jewish mother and the Catholic father. And he affirms that he is a practicing Christian. He is told shortly after his interview that he's indeed received the position, and they're just doing some formal paperwork. And at that point, he actually resigns from his current job. So one lesson from this is probably don't do that until paperwork is signed, but okay. So about a week later, he hears that the hire has not been approved. And when pressed, because he is friendly with the head coach, who had been, I think, the assistant coach when he was on the team, tells him, well, it was on account of your Jewish descent. And in a clarifying text message, the head coach says that the president had rejected the hire because of his Jewish blood. So the president actually says, I don't recall using that phrase. But what Bonadonna does is he files an EEOC complaint, an Equal Employment Opportunity Commission complaint. And in that complaint, and I know this is also hard to see, he checks the box that he is filing it on the basis of, can anyone see what it says? Race, yes. So he's filing it on the basis of race. And he then obtains a right to sue letter, which is the EEOC process. And after that, he then files a Title VII claim, right? So tiny bit of context, right? Title VII comes from the Civil Rights Act of 1964 that bars employment discrimination on the basis of race, color, religion, sex, or national origin. Now, you maybe have a question, right? Why did he choose race, and why didn't he choose maybe religion or national origin from the menu of options? Well, it seems that he did not think, and perhaps he was right, that his religion was in dispute. He very clearly was a Baptist person who, in fact, underwent his conversion experience at that college, right? So it didn't seem to him that this had anything to do with religion. He's a church-going Baptist person. And the reason he doesn't file for national origin, although it's not entirely clear, I would presume that he was being advised by a lawyer, even when he filled out the EEOC paperwork. And there, in fact, was a decision from 1990 that had made pretty clear that somebody who is Jewish is not necessarily protected by national origin, because Jewishness is not a national origin. And this was a 1990 case. So I think the lawyer probably knew that that was not going to be a kind of easy bar to pass. So the court then is in the situation of having to determine if he is eligible for federal protection based on his race. And in figuring out the legal question, the judge notes, first of all, that race is not defined in Title VII. And he says, well, this often is not a problem, right? Because often he writes Native Americans, Jews, Mexican Americans, Eskimos, and you see that kind of comparative logic swirling. Those who might kind of trouble the category of what is a race, they're usually able to kind of fit under one of the law's other terms. So it doesn't matter, right? There's just not an issue. But the judge writes, the unique facts of this case force the issue of whether discrimination based on Jewish heritage is discrimination based on race. So here's how he puzzles through. First, he thinks about precedent. And he looks, and there is this case that went up to the Supreme Court in 1987. It had to do with anti-Semitic graffiti at a synagogue in Maryland, in Silver Spring, Maryland. And the case had, in fact, offered, by the time it got to the Supreme Court, offered civil rights protections on the basis of race to Jews. But it had done so under an 1866 civil rights statute. And the way that the court had said that this was applicable was not to say that Jews are a race, but to say that under the terms of the law in 1866, this is an originalist argument, Jews would have been conceived of as a race. So therefore, if we think of the intent that Congress had at that point, their intent would have been to protect Jews. So the judge says this is not helpful precedent because when it comes to the Civil Rights Act of 1964, he does not believe that originalist claim would fly. He does not think that Congress in 1964 thought the way that Congress in 1866 did about Jews. So he also notes that prior Title VII claims also are not really good precedent because they had mainly been filed when they came to Jews on the grounds of religion. Okay, so then he's searching for some analogies, and he expands his view to look at Title VI cases as well. Title VI cases have to do with discrimination in educational settings. And so he's looking and he's saying, okay, what about other kind of elements of civil rights law? Where else have Jews gained protection and for what kinds of categories? And he thinks this might be more useful. Because again, for those of you who sort of follow the intricacies of these different titles, whereas Title VII protects religion, Title VI does not protect religion, right? It doesn't explicitly name religion as one of the protections. And he says, okay, so given that religion is not named in Title VI, and given that the petitioner now in front of me, did not choose to make a religion complaint under Title VII, what can we learn from how Jews have fared in these Title VI cases? And what he did, what he traces then is an interesting transformation. He says, well, initially, in the earlier cases, and so 1977, the Department of Education that's charged with dealing with Title VI complaints, right, because they have to do with educational discrimination, its Office of Civil Rights and the Department of Education had been pretty clear that Jews were not protected under the terms of Title VI, that Congress had made a decision to exclude religion, and it had written, the Department of Education had written, that classifying Jews as a race was, quote, inconsistent with the weight of social science and anthropological scholarship regarding racial and nationality groups. But in the early 2000s, there was a case about a Sikh student, and the courts had rethought, and they had issued what was called a Dear Colleague letter, right, to sort of say there's been a little bit of a shift in how they're thinking about them. And they say that actually there is jurisdiction against national origin discrimination that can be used also to protect religious characteristics. And they specify that they mean people who are investigating claims about Arab students, Muslim students, Sikh students, and Jewish students. That national origin maybe is a fuzzier kind of category, and that groups that maybe one would think of as religious actually could be understood under the protections of national origin. So he's learning a little bit from this case, but he's still not entirely sure. And then he looks towards scholarship. And he looks specifically toward the scholarship of a lawyer named Kenneth Marcus. And his name may be familiar to some of you. Kenneth Marcus was the head of the Department of Education under the Trump administration. And Marcus is now the head of an organization called the Brandeis Center that is working very hard on legal strategies to file Title VI claims on behalf of Jewish students at universities, specifically when they're making claims about anti-Semitism and really very specifically about anti-Zionism as anti-Semitism. And he, first of all, gets to Marcus because Marcus had written that 2004 shift to say, well, maybe Jews can be understood under national origin, and that Marcus was creating a kind of legal runway to consider Jews as a race under these titled protections. And so weaving together analogies and scholarship and quoting really directly from some of Marcus's scholarship, the judge thinks he has found, and he rules, that there's legal footing to suggest that a Jew who was, quote, declined a job because of Jewish heritage or blood has been treated like a racial group that Title VII was designed to protect from employment discrimination based on membership in that group. And what happens is that the Jewish community is not happy. So the headlines, Louisiana judge says Jews are a race. If you followed the Whoopi Goldberg controversy, right? So this kind of spinning around and the lack of clarity about these categories as if they should be real, and they are real because they're enacted in law, but are they real, right? Immediately happens. And the ADL chapter in Louisiana is furious. And they say that they are doubly offended by the perception of Jews as a race and by what the college did. Both of these things, awful. And they try to correct the judge's legal interpretation. And they say that the 1964 Congress was not at all interested in categorizing Jews as a race, and that these are antiquated views and they have no standing. And they say the decision is perpetuating harmful stereotypes and views about Jews. So in other words, even in protecting the plaintiff against discrimination, the ruling, the ADL is arguing, has actually diminished Jews' effective citizenship, which I think is really interesting. But the coda to this case is that it settles. So I was like, what happens next, right? But what happens is, Jesus, they discover, the college and Bonadonna discover that they have common ground over religion. And the president says how pleased he is that these Christians have settled disputes among themselves, and we pray God's richest blessings upon Mr. Bonadonna. So that's how it ends. So what do we learn from all of this? I'm going to conclude and then happily take your questions. I think, one, we most significantly learn that the history of American Jews' emancipation and citizenship did not terminate upon Jews' arrival to this country. Through Jewish comparison cases, through cases about Jews' formal citizenship, and through cases that adjudicated their effective citizenship or their substantive citizenship, administrative and judicial state bodies interrogated the civil and political standing of Jews and their Jewishness. The legal imperative to classify people for the purposes of citizenship posed a persistent, and I would argue continues to pose, a question about where Jews fit into the civil and political structure of the United States. And in Jewish comparison cases, we see Jews being used kind of as a muse, right? To think about the relative stability or instability of their standing, reflecting on that of other groups, and other groups' standing reflecting on their own. In formal citizenship cases, we see Jews as a direct line of inquiry, with their standing based on precedent from other groups and creating precedent for other groups, but also with a kind of specificity that really did show that the American state was sometimes looking quite specifically at Jews as Jews. And in effective citizenship cases, the categories and rights upon which citizenship rested, those were the subject of inquiry. And the answers determined the efficacy of Jews' legal personhood and belonging, sometimes cutting in multiple and opposing ways. So we learn really that citizenship for American Jews was relational and conditional, and it was contingent on historical forces and contexts, which all can and do change. It was not simply an all or nothing affair or a clear point of arrival. And to understand American citizenship law, we have to understand the presumptions embedded in it. And more broadly, just sort of as I think through all of this, I think these cases allow us to reflect on why modern nation making has been so relentlessly tied to the project of exclusion. That to me is sort of like what this comes down to when I think, why do I care about this? Why is that project of making modern nations so tied to the project of exclusion, even among governments that really like putatively embrace the most liberal terms of belonging? And even in the very process of enacting those terms, legal regimes of exclusion appear to be essential. What justifies, I wonder, these kinds of endless calculations of who belongs and who does not? Is it scarcity of resources, scarcity of compassion, of will to conceive of belonging without kind of relentless special reasons to exclude groups of people? And finally, is this modern era truly defined by stories of emancipation, of freedom, or should we maybe emancipate ourselves from that story so we can more clearly see the unfreedom in our midst? Thank you.
Thank you so much, Dr. Berman. We'll take questions if anyone does.
Did he get the job?
Did he get the job? That's a good question. I think he ends up having, yes, he ends up having a position there. So he does end up getting the job. Yeah. Yeah, you have to look at what their record is.
I think it must have been about 20 years ago. I'm not sure. I, as a teacher, brought my students to an event where a number of colleges were presenting flyers to high school seniors in New York City, asking them to be interested in applying to the colleges that they represented. Now, at that time, my son was receiving his doctorate. So being the Jewish mother, I wanted to know if he would be considered a teacher for a teaching position at one of these universities. Now, I went to, various universities. One of them was a Christian college. So I assume it wasn't a state college. I don't know. It could have been a private institution.
Yeah.
The person who was inviting the students to come, said to me, "No, your son will never be considered for a teaching position at our college because we accept only Christians as teachers." Now, I don't know if that ruling has changed, but that also sounds quite discriminatory. Now, maybe a private, and I'm wondering, does a private institution allow for that? Or does our government allow for that is legal today?
Yes. Yes. And also, just to be fair and clear, there are Christian colleges or Jewish colleges or any other religious colleges who will employ it's not definitive of that kind of college necessarily, but in private institutions, right, there is more malleability. Now, there is case law even about that, right, because part of the Civil Rights Act of 1964 was to actually try to make inroads not just into totally public spaces, but also private. But it does not entirely, so for example, if you're a private club, you can have discriminatory policies, right? So the issue of kind of funding, now, one might argue, well, if you're a private club and you're claiming 501c3 status, you are de facto getting a kind of public expenditure, right? But there is still the sense that there are certain things that private institutions can do.
Last case you discussed, from your description, it sounds as if what the court was ruling was that this man was treated as a Jewish person. That was treated as a race, and therefore we're ruling in his favor. Not that Jewishness is a race. Seems like it was an overblown misreading of the of the case, and also, with all due respect, it doesn't, that holding doesn't seem to offer any support for your thesis then. Am I missing something?
Well, so I think it's a wise observation, right? That part of what the kind of difficulty is if somebody gains protection under discrimination on the basis of race, does that mean that that person is a race, right? Now, I think from reading what this judge wrote and his reasoning, I think he wasn't as sophisticated as you are in thinking about it, right? I think he was like, yeah, okay, like he's a race. That's fine, and he should. But part of the issue is, what does it mean to have the classification of race as a threshold for certain kinds of protections? If we, as scholars anyway, and I think many people in the public who continue to sort of read and think about these things, imagine race to be a constructed category, right? Which doesn't mean that it does not have real implications, right? But actually, race is something that's made up, right? There's a construction of it. But how is the law kind of reifying it or making it real by making judgments based upon it? And if, for example, the judgment is made that Jews are classified as a race, it doesn't necessarily say that their effective citizenship is more or less, but it's simply saying that in this way, they are not purely inhabiting sort of the neutral individual category of citizenship. And maybe no one is.
How would you explain the basis for the rejection of the St. Louis during the 1930s? Was that a legal issue? Was that a refugee problem? Why were the refugees on the St. Louis excluded?
So I think I would need a whole other talk to explain, a kind of thesis for that. But I think all of the reasons you just stated were part of what the anxieties were. And I think that there was a lot of concern. I mean, that was the kind of nativism that I talked about to contextualize those Jewish comparison cases, right? And the fear, and this is exactly this question of why is so much of the project of nation making about exclusion, right? We don't have to go back to the St. Louis in the 1930s to think about refugees who are excluded from entering our country, right? So what is that? You can say there's depression and economic circumstances, and you can say that there's concern about certain kinds of people not being able to be fully incorporated or assimilated into American life. You can say that there's a certain value of citizenship, and somehow that value is presumed to diminish if there's a simple kind of openness, right? So, it's also the case that even the category, the kind of legal international law category of refugeehood was really not developed at that time. So there are other ways now we talk about refugees, but nonetheless, it doesn't mean that we simply throw open the gates.
I have a question. At one point you mentioned the quote that you included said, these Zionists, and you said, I can talk more about this. And I'm really curious how that's kind of played out since, especially, at that point you were talking 1947, and since then with Israeli statehood and this kind of renewed accusations of dual loyalty. I'm curious if that's played out in the legal structure.
Yes. Right. And so I very briefly mentioned Kenneth Marcus's work, and part of what he is trying to claim is that any invocation of Zionists is de facto an invocation of Jewishness. And in my opinion, that is not a sound argument to be made. However, it's interesting to kind of excavate the history of, at what point is the sort of sense that Jewishness is sort of, conflated, say, with Zionism. Like when is that kind of understood as part of this kind of broader trope of dual loyalty, right? Which is one of the tropes of anti-Semitism, that Jews can't really be loyal to any particular kind of state authority because they have this national loyalty, right? And part of the language of Jewishness used, for example, in the late 17th century when Jews were petitioning to be able to stay in this city when they came, and Peter Stuyvesant said, I don't want you 23 Jews in 1654 coming and staying here. They describe themselves as a nation, and they say, you don't worry too much about us. Like, we're our own nation, we're our own group, right? So these kinds of pushes and pulls of to what extent are Jews kind of nationally separate, and to what extent can they be invested with the full citizenship of a separate sovereign nation state? What's interesting in the Lapidus case, where that phrase is used, is it's really clear to the American Jewish Congress and Committee that this is not just about Jews who would happen to say, like, I believe in the Jewish National Project. They believe that it sort of smacks of a sort of broader effort to start to wear away at or deteriorate the efficacy of Jews' citizenship, to the extent that they think that a Jew is being stripped of his citizenship because of it. But the case I didn't talk about, the 1967 case that ends up being the architecture for dual citizenship in the United States, is really a kind of robust defense of the idea that an individual could have multiple sovereignties. And it ends up sort of using Zionism and Jews as the paradigm for that, right? Which is so, and it's a product of the Cold War, I think, but it's a super interesting move. I think in the current legal context in which that conflation is being used to make allegations of anti-Semitism, especially on campuses, I think there are a lot of complexities about how it's being written upon Jews in a way that is kind of meant to define all Jews as being Zionists.
I'm just curious whether you think that there's sort of a less flattering to Jews way of analyzing all of this, which is an effort to sort of to become white, and the whole sort of American history of categories of people who are now thought of as more white, trying to become white, like Italians or Irish or whomever. And is that part of what's going on in this story?
Oh, absolutely. And I don't know that I would use the language less flattering. Those are the rules of the game. I mean, you really see that very clearly set out in those racial prerequisite cases. And in fact, the reason I think that statement at the end of the Bonadonna case is so interesting is it is this kind of testament to like full Jewish incorporation in whiteness qua super secessionism in Christianity, right? And I think like a place where scholarship on whiteness in the United States hasn't quite gone, even though James Baldwin, right, the kind of Harlem Renaissance, well, post-Harlem Renaissance novelist and thinker and intellectual, Black intellectual, sort of says as much, is that the problem with whiteness in this country is the problem of Christianity. And it's this logic of not just sort of letting everybody come and be who they want to be, but actually kind of pulling groups into this kind of Christian framework of what America must be. And if they can't be that, then they need to be excluded. And I think we see sort of resonance of that even in replacement theory, right? So it's not to me necessarily unflattering to kind of think through that process of whiteness. I think it's structuring so much of how American law works. And it's one of the reasons, actually, I think that we should be thinking about anti-Semitism as having a kind of structural presence in the United States.